Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session pursuant to adjournment. God save the Constitution and this honorable court.
Good afternoon. Welcome to the 14th Court of Appeals, coming to you this afternoon by Zoom. I am Justice Frances Borleo, and with me today is Justice Megan Hassan and Justice Margaret Poissant. We are here to hear the case 14-18-00995 Hotze et al. Versus IN Management LLC et al. Each side will have 15 minutes to present argument. If the appellant would like to reserve a portion of that time for rebuttal, please let us know and we will set our clocks accordingly. We have read your briefs and we are eager to hear your arguments, and you may begin whenever you are ready.
Thank you, Justice Borleo. May it please the court, I have, with the court's permission, reserved 3 minutes for rebuttal. This is a family fight that's gone into the courtroom. It's over a closely held family business, several family businesses. This was a jury trial. There was no agreement to bifurcate or submit any issues to the trial court. I represent the plaintiffs, David and Bruce Hotze, and their Hotze family trusts. I've provided the court with an argument exhibit. Exhibit number A is just a demonstrative to let you know what the heart of this dispute was all about. Before September 2015, this was the ownership graph of the family-held corporation. After September 22nd, 2015, this was the graph of the family-held corporation. 3 of the brothers maneuvered in such a way as to gain 96% control of the corporation. The other piece of the information is they did so by claiming par for the stock, only partially converting their note. They turned a $2.5 million note, kept the note, but took over majority control of the corporation. My argument today is not really dealing with that transaction in particular. I think there are 2 points that dispose of most of the issues in this case, and I'd like to address those 2 points, which I believe will result in a rendition of a reversal and rendition of the trial court's judgment, and to have the case remanded in part when we get to the end. We also seek a reversal and remand of the informal fiduciary claims that were brought against both both on behalf of the corporation and also the individual claims. The trial court truncated those, and we're asking for reversal there and remanding on those issues at the other end, but we're relying on our briefs for that. Our first point I want to bring to the court's attention is the Texas Theft Liability Act recovery by the defendants of $2 million in attorney's fees. There was no pleading, no expert designation, no discovery, no proof, no jury question on or any jury finding about the reasonableness and necessity of the fees. We've cited the court a host of cases, Lawler, Shaw, Intercontinental Group, that all indicate that the appellees here failed to take any step required for the recovery of attorney's fees. Now, I understand the defendants say, well, the statute says that the fees are mandatory. Well, it doesn't. It just says that trial court shall award fees if there's a result in that case in favor. But in Ray Ben, Texas Supreme Court case in 2016 very clearly says you got to ask for the fees and you must prove the reasonableness and necessity to the jury. There was no argument about this because not until after the jury was released and the trial court was considering as a judgment was the first time a claim for attorney's fees came forward. And the only argument was, well, the statute says you got to award them. In Ray Ben says that's not how it works. You've got to go to a jury on reasonable necessity. And furthermore, to bifurcate a jury trial, an agreement is required, and particularly under Civil Practice Remedies Code, section 38.004, you can submit attorney's fees to the trial court, but it's got to be by agreement. There is no agreement. We believe the judgment should be reversed and a take-nothing judgment for the appellants should be rendered on the attorney's fees.
Counsel, you do agree that attorney's fees under the TTLA are mandatory though, right?
Your Honor, I agree that the trial court does not have the discretion when requested to not award the attorney's fees. But In Re Ben answers the question very clearly. If it's a jury trial, the jury has to decide what's reasonable and necessary. And so it can't be brought just to the trial judge to make some sort of decision about it. We believe In re Bent answers the question. We believe it should be rendered. Our second issue is Exhibit B that I provided to you, which is the Business Organizations Code. It's section 21418. That's a major part of this litigation. Under that statute, a stock transaction by interested directors is void or voidable unless the transaction is approved by a majority of disinterested directors in good faith, or when ratified by the board of directors, the transaction is fair. I understand in a lot of the briefing, the defendants have all said, well, but we ratified the transaction. Well, a careful reading of the statute, in that case, there's two things that have to happen. Either it's approved in good faith by a majority of the disinterested directors, or if it's ratified by the board of directors, then the transaction is fair to the corporation. Those standards are both in subpart B1 and A and B2. And the defendants do not dispute, the evidence has established that this underlying transaction was an interested director transaction. And the only question for the jury was whether the transaction satisfied the safe harbor of 21.418B1 or 2. If not, the conversion is void or voidable by the court. Now, Texas Rule of Civil Procedure 279 says that the safe harbor is an affirmative, independent defense, avoiding the transaction. It is a burden squarely placed on the interested directors to prove either that a majority of disinterested directors in good faith approved the transaction, or when the board of directors ratified the transaction, it was fair to the corporation. They did not prove this. Neither asked of the jury nor established in the record that a majority of disinterested directors in good faith approved the transaction, or that when the board of directors ratified it, it was fair. The jury was never asked that question, and this record is far from establishing that it was either fair or in good faith.
How many?
I'm sorry, Ron.
I'm sorry to interrupt you. How many directors would have been considered disinterested at the time of the vote?
Your Honor, there would have been 4 disinterested directors. We never had a majority of 3 disinterested directors vote on it. And I think the brief covers what happened with a proxy, with you vote however you want to kind of thing in there. But we don't think we actually reached those questions because the transaction as a matter of law can't be saved, because the question of whether it was in good faith or the question of whether it was fair was never submitted to the jury. I call the court's attention to question 10. Question 10, a lot's been made of question 10, but question 10 misplaced the burden. The question failed to require the defendants to show, nor did it ask the jury to find that a majority of the disinterested directors approved it in good faith, nor does it ask the jury to find that when ratified by the board of directors, the transaction was fair to SECO. I remind the court that a failure to find is not a finding. It is simply the conclusion of a jury as it was instructed, that if evidence does not preponderate in favor of a finding, the question must be answered no. In short, here, that the jury failed to find the defendants were not in good faith or not fair is not a finding that they were. Not only was the question improper, it cannot be used in a belated effort by defendants to get a second bite at the apple. The rule 279 requires that upon appeal, all independent grounds of recovery or of defense not conclusively established under the evidence and no element of which is submitted or requested are waived. 279 says it's waived. Now, the defendants may argue that question 10 at least introduced some elements, but it is significant. The question was requested by the defendants and it was submitted over the plaintiff's objections. I'm sorry we don't have it in the brief. I'll give you the site from your sister court, the First Court of Appeals. The name of the case is Winfield versus Renfo. It is 821 Southwest 2nd, 640. And I'll read from page 657. Winfield goes on to argue that when a disputed or essential issue is omitted over the objection, of one party, the appellate court must find that the party waived that element and by so doing did not meet the burden placed on him by law. We agree. Winfield claims that when an issue is submitted with an missing element, and the party who did not have the burden of proof objects, the appellate court must reverse and render, not reverse and remand for new trial. Once again, we agree, and they cite a number of cases for that proposition. Because the defendants expressly requested an improper jury question, and we objected, the court should render judgment that the stock transaction is void. Now, because the trial court never reached the question of the proper remedies, which are under Business Corporations Code 21914, we request the case be remanded for that purpose. Now, in the event the court determines that defendants are entitled to a second bite at this apple, we request the court at a minimum to reverse the trial court's holding that this convertible note could be partially converted. The actual language of the note says that it can be converted for the aggregate amount of the principal and interest accrued, and the note must be surrendered. Now, the argument is, well, you might read this to be partial. Well, if you read, then it's ambiguous. It is certainly not read as a matter of law that could partially convert. And there's any number of reasons for that, which is exactly that first document. They had a $2.5 million note that they were allowed to convert for the aggregate principal and interest and take stock in exchange. They chose to only give credit for $38,000 and take a $2.5 million note. So they maintained their position, their preference over all equity owners. They maintained the debt, and they argued they took control of this corporation, which weeks later they said was worth over $30 million. That's why that provision can't be read the way they said it's read. They have the option to convert or not convert, but they can't convert partially, take control of the corporation, and then come back and say you still owe us debt.
So, Counselor, how does the resolution that the board passed affect the loan?
Your Honor, the resolution are you talking about before the loan was executed? Or
No, afterwards. Wasn't there a resolution afterwards by the board?
Ratification, Your Honor. There was a ratification, but the burden was to show that at ratification, it was fair to the corporation. They didn't have that burden. That question was never placed. The burden was never placed on them. But if you say they're entitled to go back and retry their case with the proper burden, then my argument here is that we need a correction of the trial court who said, well, you can partially do this and do what they did. This note does not give them the power to partially execute a conversion and maintain debt. I know my time's up. We ask the case be rendered on the 2 points I said, remanded for the assessment of penalties and remanded for us to try the informal fiduciary duty cases.
I think I'm on. Can the court hear me all right?
Yes, you may proceed.
Yes.
Thank you. Jesse Pierce on behalf of the Hotze appellees in management and the Internos entities, all, pardon me, of whom are appellees. I'd like to talk first about the partial conversion issue. This promissory note does not say a total conversion is required. The fact, the undisputed fact, is that this company, Seco, was on the verge of bankruptcy, and a total conversion was not possible because the share values would not support it. The Class A stock had to be valued under the Business Organizations Code and the bylaws at $1 per share, and the non-voting Class B stock at 1 penny per share. When that stock is valued in accordance with the statute, there simply was not enough value to permit a total conversion. But I want, if I may, very quickly to step aside for a moment before I get into the details of the propriety of the partial conversion and just ask the court to consider the rhetorical question, what if Troika had done a total conversion? The situation would be exactly the same, except arguably there would have been no new note. The appellants have given the court this pie chart, which shows the ownership of the voting shares after the conversion the way it occurred. It is undisputed. Had there been a total conversion, this pie chart would look exactly the same.
How do you address the question, Counselor, that the note, upon conversion, the holder shall surrender this note at maker's principal office?
Well,
why wasn't the note then surrendered?
It was not surrendered, and this is explained in the briefs, if I recall correctly. The note was security for Comerica Bank, which was a secured lender. Comerica had possession of the note, and until SECO reached the point where it was able to satisfy the bank and get the note back, it could not be surrendered. As soon as that occurred and Comerica released the promissory note, it was tendered to SECO and the new note was executed. And on that point, while it does say that the note is to be surrendered, which was physically impossible and legally impossible here, that, to my mind, at least my analysis, that doesn't really deal with the question of whether the partial conversion was proper or not. The appellees submit that the trial court properly construed this note, but let's say somebody has a doubt about that. The appellants have a number of hurdles that they have not and cannot clear. The first is the September 22nd resolution by the board of directors that authorized the conversion as it took place. When the court looks back at the appellant's brief, primarily David Hotze's brief is the only one that really discusses this point. What they say is one reason that they say that September 22nd resolution was ineffective, and that is that it did not receive the proper vote of the disinterested outside directors. That is wrong, and that is wrong as a matter of law, which is one reason question number 10 is immaterial. We had 4 outside disinterested directors. Mr. Blackburn and Mr. Sullivan, who were disinterested outside directors, voted yes. Peter Schwab gave his proxy to Ed Mattingly with instructions that are discussed in the brief. I'm voting yes unless something dramatically different happens. Nothing dramatically different having happened, Mr. Mattingly voted that proxy yes. And I understand the appellants raise questions about, can a director vote by proxy? Well, certainly, as the court knows, there's no prohibition on it. It's not addressed at all. But again, putting that question aside, the 4th director, Edward Mattingly, abstained. The effect of an abstention under the bylaws of SECO, section 4.8, and under section 21.414 of the Business Organizations Code as it existed on September 22nd, 2015, is that an abstention is an affirmative vote unless a dissent is registered in the records of the company, which undisputedly was not done. Therefore, as a matter of law, we have a minimum of 3 of the 4 interested directors, a clear majority, voting in favor of this resolution. And I submit that under the TBOC, it was unanimous because Schwab's proxy exercised by Mr. Mattingly was an affirmative vote. But even if the plaintiffs, the appellants could get over that hurdle, this transaction was ratified. The action of the board on September 22nd was ratified in 2018. This was not attacked by the plaintiffs in the trial court. No issues were submitted or were submitted. They didn't complain on appeal of the trial court's failure to submit it. Although, and this is interesting, the issue, which was proposed question 46 that they tendered, dealt with section 2.418, not section 2.914, which is where they asked for the basis on which they attacked the ratification. I'm under 2 minutes, so I'd like to turn very quickly to the attorney fees award.
Counsel, you are under 2 minutes, so I have a quick question.
Sure.
I was wondering if we could turn to the informal fiduciary relationship, informal fiduciary duty claim quickly.
The
I'm sorry?
informal,
Yes.
this is the court referring to the point that the appellants raised that they were not permitted to amend?
Right. The
Yes,
trial amendment.
yes. They waited till the last minute. They admitted they hadn't pleaded it. We were, as I recall, had a jury panel waiting. It was untimely, simply not pleaded, and they concede they didn't plead it.
So was there a summary judgment that your clients filed prior to the trial asking for a summary judgment on the informal fiduciary duty claim?
I believe we responded to their motion for summary judgment, but certainly the question of the existence of an informal fiduciary duty was mentioned in some pretrial pleadings, but those, of course, do not constitute a pleading. We've cited those cases. I'd like
Why would they be contained in a motion for summary judgment if you didn't consider them to be contained in the pleadings?
Well, it appeared to be a point that, well, it was a point that they were raising, that the plaintiffs were raising. There was some suggestion in the whatever document was being responded to that there might exist an informal fiduciary duty. And could I very briefly respond very quickly on the attorney's fees?
Yes, of course.
I'd like to point out that the plaintiffs made a strategic decision here, the appellants, not to contest the appellee's evidence, the affidavits on attorney's fees, and they passed on the opportunity, which we offered, to have a subsequent jury trial if they wanted a jury trial on attorney's fees. But I should also point out, this will take 30 seconds. The Theft Liability Act is unusual, as this court recognized in error routing on several grounds. But under section 134.005A1, it says that damages are to be awarded in the amount of actual damages found by the trier of fact. It specifies trier of fact. It then goes on to say the additional damages up to $1,000 awarded by the trier of fact. But then it says each person who prevails shall be awarded court costs and attorney's fees. There is a bifurcation within the body of the TTLA that the legislature consciously wrote that the trier of fact makes certain determinations and then just says reasonable and necessary attorney's fees, which are not disputed here, shall be awarded. It's mandatory. And while there is no case on this that I have found, this reading and construing what the legislature did suggests that actual damages are for the trier of fact, a jury, and that the court is to determine and award the attorney's fees. Thank you.
I had one last question actually about your attorney's fees. Do you have any response to the appellant's argument that you're not entitled to them because you didn't plead them?
I would refer the court to its decision in the, I think it's the state of Nunu case, which says there is no requirement with mandatory attorney's fees, no pleading requirement. If there are no other questions, I suppose Mr. Prime will remove me here.
Thank you.
Thank you.
You may proceed whenever you're ready.
Thank you, Your Honor. May it please the court. My name is Eileen O'Neill, and I represent the outside directors of SECO, Mr. Peter Schwab, Mr. Ed Mattingly, and Mr. Tommy Blackburn. As the court is familiar, this is a family dispute about a family corporation that was near bankruptcy. 3 of 2 brothers decided to try to save it through the Troika note by advancing money to the corporation. 2 brothers chose not to risk their personal wealth to do so. But when the Troika note succeeded and the corporation turned around, those 2 brothers had second thoughts and brought this lawsuit to sue their 2 brothers, including for theft, and also sued the outside directors on the board of directors. It's a gotcha case. This case was tried for 4 weeks, hotly disputed issues, many of them regurgitated in appellant's briefs. The jury saw the case for what it was. They answered 45 questions, all of them against the appellant. And then the court correctly awarded mandatory attorney's fees under the Texas Theft Liability Act against the appellants. The outside directors have submitted an oral argument exhibit, which diagrams the 3 reasons why there is no reversible error in the judgment holding that the outside directors have no liability. You can follow along with that. The first reason is that questions 29 and 31, which were the breach of duty questions submitted against the outside directors, were improperly predicated on question number 10, which had nothing to do with the outside directors. And so they were not answered, and that presents no issue for review and reversal. The second reason is that questions 29 and 31 were immaterial because they never should have been submitted in the first instance, as there is no evidence that the outside directors committed an ultra-virus act or fraud in connection with approving the transaction. And third, there are independent grounds to support the judgment, which is the waiver finding of the jury in answer to question number 4, which the appellants have not challenged on appeal. Moving to the first argument. There is no error since the liability questions against the directors, the outside directors, 29 and 31, were not answered. And they weren't answered because the appellants predicated it on question 10, which has nothing to do with the outside directors. And I will say 2 things before I move on in this respect. Number 1, throughout this proceeding, the appellants have conflated all the directors as if they were in the same position. They were similarly situated, which is not correct. And number 2, the argument you heard today about the directors requesting question 10 and that impact of that in not obtaining certain findings is an entirely new argument that is not in appellant's briefing, and it's wrong. There is a difference between the burden to request and the burden to persuade. And even if appellant's position were that someone among the directors had a burden to persuade under question 10, they have not argued and supplied no authority for the proposition that the directors had the burden to request that question, and they didn't. As the court will see in Clerk's Record, Volume 7, 3613, 3616, 3555, and 3558, it was the appellants who requested question number 10 and also requested questions number 29 and 31 against the outside directors, which were improperly predicated on question 10. Why is it an improper predication that they requested? But the reason that it's improper is because it submits 21418, which has nothing to do with the outside directors. That only is a gateway, as they refer to it, issue that enables them, if found correctly, to sue interested directors for a breach of duty. But the outside directors were found as a matter of law to be disinterested directors. And as disinterested directors, question 21418 can have no impact on any liability as to them. The second reason that the judgment is correct is because 29 and 31 are immaterial. There was no evidence supporting their submission. We raised this in our appellee brief, and in their reply briefs, the appellants did not identify any evidence that supported the submission of those issues. And lastly, the jury found that the appellants waived their right to complain about the conversion in response to question 44, which hasn't been challenged. For those reasons, Your Honor, the outside directors request that this court affirm the judgment on behalf of the outside directors.
Hey, I found the right switch. May it please the court, in my few minutes remaining, I wanted to address a couple of things. One is we went through the entire argument by the defendants, and not once did they mention 2114's burden of proof. They had the burden of proof. They didn't exercise the burden of proof. And I appreciate all of the discussion about the facts of this case, but that's neither established as a matter of law in the trial of this case, nor did the jury find that those facts were correct. And as to the independent directors, 21418 says, as to this specific transaction, if B, that's the good faith or fairness is satisfied, then the directors cannot be sued for that transaction. This statute says nothing about what happens if it wasn't in good faith by the independent director, by the disinterested director. What happens if it wasn't fair to the corporation when it was passed on? 914 of Chapter 21 has a panoply of remedies a trial court can award for a void stock transfer. Now, I want to address one other thing that was said about this whole deal, about kind of the transaction. You heard them say that the three brothers loaned the corporation $2.5 million. That's what saved the corporation. Then what they did is they gave the corporation a minuscule credit, $38,000, and took control of the corporation, kept the debt for $2.5 million, and then within weeks started marketing it as worth $30 million. That's why there's no partial conversion of that note. Yes, ma'am.
Sorry, I have a question. If we determine that the promissory note did not allow for partial conversion, what does that do to the remaining issues and claims? And what do you think is a proper disposition of them?
Well, Your Honor, too, I don't think you have to reach that. The only way you'd reach that if you decide the defendants get a second bite of the apple on the burden of proof. If you remand so they can now try to prove that they were fair or try to prove that they did it in good faith, then yes, it makes a difference to the outcome of the case if it's partial conversion, because if it doesn't allow partial conversion, then we do have damages for the control of the corporation that was never properly authorized. So we move forward on that. We also have our claims for informal fiduciary duty, because these are brothers. These are brothers who operated this business together, and this is the informal deal. And the partial thing also is relevant to the remedies. Under 914, you'll have a judge who can allocate remedies to remedy this partial conversion. So the judge will have the power under that statute to do so.
Was there a jury, I'm sorry, was there a jury question submitted on that, on a breach of fiduciary duty claim? Or was that one of the ones that was struck? I can't
No,
remember.
Your Honor, the judge would not allow the amended pleadings, but as Mr. Pierce conceded, we argued about it and argued about it and argued about it throughout the case. And then we said, well, if you want us to have an amended pleading, we'll file an amended pleading. Well, no, I'm not going to let you amend your pleading. So we think.
No, I wasn't talking about the informal duties. I was talking about any breach of fiduciary duties for the derivative claims. Those were.
Yes, Your Honor, we did have breach of fiduciary duties for the derivative claim. As I said, 21-418 only restricts claims if they satisfy B on the stock transaction. But there's nothing in that that says that other claims that could be brought for misdealing are somehow limited.
Right.
And okay. We think that two things ought to be rendered. We think that stock issue is void. That ought to be rendered. We think that the question of the defenses ought to be rendered because they didn't ask for the right question and they didn't get the right answer. And we objected to that question. And so they don't get to retry that case. We think it gets remanded under the section 21-918 for the judge to now apply the appropriate remedies for the stock vacation. And we do think we proceed on our fiduciary duty claims against the corporation and the directors. And oh, by the way, no attorney's fees under the Theft Liability Act. They didn't plead for it, and they say they didn't need to plead for it. But Burt does say that they've got to try the issue of reasonable and necessary, and they didn't do so. And the fact that post-judgment, they come in and start putting a lot of documents in the record, we don't lose the absolute right to get a rendition on the attorney's fees.
Counselor, could you tell me the timing of that? There was a verdict and then an affidavit for attorney's fees was submitted. How long after?
After judgment, I believe it was after judgment, but it was certainly after the verdict was accepted by the jury. And I think it was like weeks after.
And it was a motion, I presume a motion for entry of judgment was made at the conclusion of the trial and you know, at the conclusion, okay.
Yes, Your Honor. But again, nothing about attorney's fees until after the trial was complete, the jury was discharged, and the verdict was accepted. And then all of a sudden they come up. And when I say all of a sudden, we're entitled to have a jury decide all the disputed issues. And they waived that, and it ought to be a rendered judgment.
Thank you, Counselor.
I appreciate the opportunity. I know it's kind of unusual Zoom. This is our new normal.
It is, but we're all getting used to it, aren't we?
We are.
Yes.
We prefer to see you in person. You know, we really do prefer to see all of you in person. And, you know, it's wonderful when we have, you know, such brilliant attorneys arguing these cases. But it's also nice to see you on the screen.
But
And
we
with
look
that-
forward to, sorry.
Oh, no, sorry. I was going to say we thank you, all of you, for your excellent arguments and your very thorough briefing. This case is submitted and we are adjourned.
Thank you, Your Honor.
Thank you, Your Honor.